All right, we get tons of medical malpractice calls every week. That's why we have Dr. Malone in large part here at the office. There's not too many law firms in the state of Florida that have a full-time board-certified internal medicine physician on staff at the law firm like we do, which is wonderful. It helps speed up the review process, but the review process is somewhat more involved than a typical like car wreck case. I wanted to use this time in this video to go through sort of the steps that we utilize here at Zarzaur Law in reviewing a medical malpractice case. So obviously the phone call comes in from the prospective client and they describe to the intake person what generally happens. That gets reviewed by Dr. Malone, myself, maybe another lawyer in the firm, and then we decide whether or not the thumbnail sketch we get from the client sounds like a potential case. If it does, we schedule a more formal phone call with me, sometimes with me and Dr. Malone, sometimes with another lawyer and Dr. Malone, sometimes with just another lawyer. But the purpose of that second phone call is to get a little more detailed information about the alleged medical malpractice and the injury. Once we decide that there is something we want to actually look at, which obviously we're considering all factors, we ask for a copy of the records. If the client already has a copy of the records, we'll take what they have, but many times what they have is not a complete record, right?
Mm-hmm.
Yep. So what we have to do generally is get the records, and which means we have to get you to execute paperwork, not only hiring us, but also giving us authorization to get your medical records. We get the medical records. We do then an in-house review of the medical records. If everything is still consistent with what our impression was initially from the summary that we got from you, then we decide, okay, what experts do we need to prove the case?
Yeah, and the state of Florida requires experts.
Yeah, the state of Florida requires, one of the tort reforms is that you have to actually hire the expert before you even start the case. And then the expert has to review the records. The expert has to give an opinion under oath whether or not they think there's malpractice and whether the malpractice caused an injury. Sometimes that means you have more than one expert. And that is the records process is 3 months or so. The review process for the doctor is a month or so, or up to two months, I guess. And then after that, and under Florida law, you have to do the notice of intent. You can't just file a lawsuit. You have to do the notice of intent. It's called pre-suit period. The pre-suit period is set out in the statutes, the Florida statutes, and there's certain requirements that you have to follow. You have to provide the sworn statement from the doctor. You have to also let everybody that's potentially going to get sued know that you have the intent to sue them. And then there's a process for discovery inside the pre-suit period. The pre-suit period allows both parties to take informal statements of each other, that you can trade documents back and forth. Many times the doctor and hospital's lawyer wants to meet the plaintiff or prospective plaintiff, and they'll ask for the informal statement. Sometimes we're trying to get extra information from the doctor or the hospital. We do those requests. That period is usually 90 days. Sometimes it can be extended. And after that pre-suit period is over, if they deny the claim, then you now have clearance under Florida law to file the lawsuit.
So from the time they called until what you just described, that can be a full year.
Easy.
Yeah.
Because you got 90 days plus 3 months of review plus 2.5, 3 months of getting the medical records.
Yeah. Plus maybe they didn't call on the day that there is an injury.
Right.
So you're looking at you're a year into a 2-year statute.
Yeah, and the statute's 2 years, right? Dr. Malone makes a good point. All that, it takes a year, what I just said, and the statute's 2 years. So if you wait a year, you're pushing it already. Another reason you shouldn't wait. But after the pre-suit period is over, you have clearance then to file the lawsuit. Then you're looking at 8 months to 9 to 20 months of a lawsuit. And there's discovery in the lawsuit. So you have the pleading stage in the lawsuit. Then you have the discovery stage in the lawsuit, which is taking depositions and making sure you have all the records and asking for any other documents they may have that have come up and become relevant in the case. And then the experts get to do depositions. Then the court will require you to do a settlement conference called a mediation. If the mediation is not successful, then you're set for trial and you go to trial. So long and short of it is, these cases are not simple, they're not short, they're time consuming. We're looking at 3 years of work. We're looking at spending between $100,000 and $300,000 on the case. So we take a really good look at the case, because the last thing we want to do from a financial standpoint is involve ourselves in the case if it's going to be a loser, right? Because we're going to lose $200,000. And we certainly don't want to involve a client who's already gone through a miserable experience with their medical situation and add to that a miserable experience in the legal world. So we're very careful about the cases that we recommend Presuit in, and I wanted to make sure this video captured how lengthy the process can be and how involved it is at the different stages. If you have questions about a potential medical malpractice case, you can find us on the web at zarzaurlaw.com, or you can call us at 855-HIRE-GO. Thank you.